Let me tell you a story about my very first audit case when I was working at the tax office. So we were auditing someone claiming the small business CGT concession, and in this particular matter, this fellow owned 39% of the company, which meant that the entire value of the company wasn't counted in his assets to get under the 6 million threshold. After about 2 months of information analysis and requests and discussions, we discovered that I think it was 3 days before the sale of the company, he gave away 3 or 4% of the shares to some employees without telling us anything about it. So he actually owned 43% before the sale, which would have included the entire value of the company and meant he was not eligible for those concessions. When we asked him about this, he said, oh, it's an employee share scheme. But employee share schemes don't go from shareholders to new shareholders. They go from the company issuing new shares. And keep in mind, this was my very first case that I did. It was supposed to start with something not too complicated, look at the stuff, walk away pretty happy. But there was a problem because this guy did this scheme so close to the sale, it was clearly tax motivated. And because it was a scheme with the sole or dominant purpose of getting a tax benefit, i.e. access to these very valuable CGT concessions, we had to go get advice from tax counsel about whether Part 4A applied. Now Part 4A is the general anti-avoidance rule, which can basically operate to nullify tax benefits that you get if it's too contrived, tax-driven sorts of schemes. Now, unfortunately, I had to leave this case because I went to a new team before it finished. However, this guy got in deep shit. And they were very quick to say, we're going to amend our return, so we're not going to claim the small business concessions anymore. And it's really funny because this is actually a matter where the advisor approached the ATO under the Commercial Deals Project to get assurance on what they've done is the right thing. And it went so pear-shaped that we were looking at applying the most aggressive provision in the tax law, being Part 4A. And this is why it's my general advice to people is you don't go to the ATO to get advice unless you need to. If you need that certainty, that's the only place to go. But otherwise, you're better off getting impartial tax advice from a tax specialist advisor like myself, I guess.